Free speech. Initially, protection for free speech in the United States has been fairly limited. In fact, almost any speech could be prohibited by government if it had a tendency to lead to some kind of evil that Congress had a right to prevent. And this was fleshed out specifically in the Supreme Court case Patterson versus Colorado in 1907. But already for well over a century before 1907, since the beginning of the United States, restrictions on free speech could be quite significant. We saw that in, for example, Sedition Acts of 1798, whereby Congress passed a law and President Adams signed it that made it illegal to publish malicious, false, or scandalous information about the government. So initially, there's not much field for freedom of speech. However, there's a more leeway allowed to speech, starting with the case of Schenck versus United States. In that particular case, Justice Oliver Wendell Holmes posited the so-called clear and present danger doctrine. According to this doctrine, speech could be prohibited and in fact criminally punished if it caused clear and present danger of some evil that the government had a right to prevent. So in Schenck versus the United States, the conviction of the socialist Charles Schenck was upheld for distributing pamphlets to the draftees during the First World War that urged them to peacefully resist the draft and characterized the draft as an evil and a consequence of the evil imperialist system. Now, Schenck was convicted under the 1917 Espionage Act, which made it illegal to interfere with military operations and made it illegal to obstruct the draft. It should be pointed out that Schenck's pamphlet did not call for violence and merely urged the draftees to peacefully assert their rights, arguing that the draft was a violation of the 13th Amendment because it was a form of slavery, according to Schenck. Now, Schenck was still convicted because the court said that in wartime, greater prohibitions on speech can be imposed than in peacetime. So it's all about the context in which speech occurs. If speech causes clear and present danger of some evil that Congress has a right to prevent, then in fact it can be prohibited. Now, despite Schenck's loss in this case, as I said, Holmes's doctrine of clear and present danger in fact provides more protection for speech than the previous test of bad tendency. Now, this test of clear and present danger was ostensibly replaced a few years later by bad tendency test once again. And that happened in Gitlow versus New York. We see bad tendency again, also at about the same time in the case Abrams versus United States. And in this particular case, Benjamin Gitlow, who was a socialist, was convicted under New York State's anti-anarchy laws. In 1902, New York State passed a law that made it illegal to advocate for a violent overthrow of the United States government. And the immediate impetus for that law was the assassination of President McKinley 1 year earlier by the anarchist Leon Czolgosz. So New York State law passed these anti-anarchy laws, and one of the laws said you cannot advocate violent overthrow of government. And Benjamin Gitlow, in one of the newspapers, in fact in the newspaper that he managed, published the so-called left-wing manifesto, which ostensibly urged the overthrow of the government by force. During his criminal trial, Gitlow claimed that he wasn't in fact urging any violent overthrow of government by force, but rather he was engaged in a historical analysis, to wit, that sometimes government overthrow by force has been justified, and look at how many governments throughout history have been overthrown. However, the trial court did not buy his argument and still convicted him. And the Supreme Court upheld his conviction. Now, in upholding his conviction, by the way, by a 7-2 vote, the Supreme Court seemed to have moved away from the clear and present danger back to the bad tendency rule. And Oliver Wendell Holmes was among the two dissenting justices in this case, and he criticized the court for abandoning his clear and present danger test. And you might have heard the phrase, "You cannot shout fire in a crowded theater." That's from Oliver Wendell Holmes' Schenck versus United States clear and present danger test. However, here in Gitlow, 6 years later, Holmes was upset because the court has once again made it very easy to interfere with speech and, in fact, to criminally punish speech. So another significance of Gitlow is that it incorporated one of the freedoms listed in the Bill of Rights to the states for the first time in American history. The court said that freedom of speech is a fundamental freedom or fundamental liberty, and as such, it applies to the states through the word liberty in the Due Process Clause of the 14th Amendment. So that was another significance of Gitlow. Now, in 1951, this is the early 1950s, and we have a second so-called Red Scare. The first Red Scare came soon after 1917, after the Communist Revolution in Russia in that year. By the early 1950s, we had the second Red Scare when it became apparent that the Soviet Union not only survived the Second World War, but expanded its geographic reach by occupying many previously independent countries of Eastern Europe, and also communism had spread to China, mainland China, by the end of 1949, as the Chinese communists won a civil war against the nationalists. So now a huge swath of the earth was under communist rule, and Americans and the American government were scared of communism perhaps more than ever. And there was a case where members of Communist Party were charged, and the court, in upholding their conviction, applied the so-called grave and probable danger test. The case is called Dennis versus the United States. And the test says that the gravity of the evil discounted by its improbability justifies such invasion of free speech as is necessary to avoid the danger. So this rule gave less protection to free speech than did the clear and present danger test. Finally, we get our current standard, our current test. That's the so-called imminent lawless action test. And it comes from the 1969 case of Brandenburg versus Ohio. So the Constitution guarantees free speech, the court held in this case, and also guarantees freedom of the press, except when speech advocates by directly inciting imminent lawless action. So what has to happen for a speech to meet this standard and therefore to be outlawed constitutionally? First, the action that you call for has to be unlawful. Second, it has to be imminent. That is to say, right now, or at some very near specified time. It cannot just be an abstract advocacy of violence. You have to call for it imminently. And third, the act called for has to be likely to actually occur. This test is much harder to meet than any of the three tests that I have mentioned: grave and probable danger test, clear and present danger test, and the bad tendency test. All of those are much easier if you want to limit free speech. So, imminent lawless action test, from the point of view of the government wanting to limit free speech, is a much more difficult hurdle to overcome. By this test, much of the speech that would be considered unlawful and could be limited under the grave and probable danger test and even clear and present danger test, much of the speech is perfectly protected by the First Amendment under the imminent lawless action test. Now, I'd like to, in conclusion of this video, draw your attention to some of the interesting symbolic speech cases. Because first, I want to illustrate a point that symbolic speech is speech within the meaning of the First Amendment. That is to say, it is generally protected by it. And three classic cases that I would like to mention that illustrate the protections and lack thereof that exist. In this particular case, in this particular instance, all three cases were actually won by those who were advocating free speech. Tinker versus Des Moines is the first case decided by the Supreme Court in 1969. After some high school students and junior high 16-year-olds showed up to school wearing black armbands with a peace sign on them, they were suspended from school. And the reason why they were suspended is because the day before they came with their black armbands, the principal of the school, having gotten the wind that they were going to take this action, instituted a rule that said anyone who is wearing armband in class will be asked to remove it, and the failure to remove it is going to lead to suspension. So they were asked to remove their armbands, they refused, they were suspended from school. They sued through their parents, they sued the school, and the Supreme Court ruled in favor of these high school students, saying that schools cannot be enclaves of totalitarianism. The court's decision said that students' free speech is protected because they were not actually disrupting school activities. Had they been disrupting school activities, or had their symbolic speech been harassing some students, the situation would have been different. But in this case, the court found that the principal instituted this policy because of potential and not real disruption, and maybe also because the principal had some ideological objections to their particular speech. But neither of those is a reason enough to override freedom of speech. In other words, just because a principal as an individual finds particular type of speech objectionable doesn't mean that he or she can stop the speech. And just because there is a concern of potential disruption, that doesn't automatically give the principal the right to limit free speech. So that was Tinker versus Des Moines. Next case is Texas versus Johnson. Johnson was a communist agitator, and he was protesting America's foreign policy outside the meeting of the Republican National Convention in Houston, Texas in 1984. And he basically burned the American flag, and he was arrested under Texas state law, which forbade desecration of sacred symbols. Now, the Supreme Court, by a very narrow margin, 5-4, ruled in favor of Johnson, saying that no one or no several attributes or symbols can be placed above the First Amendment, above the sacred liberty of speech. So Texas lost and Johnson won. It's interesting that since that decision was made, the Congress of the United States repeatedly, almost every year, attempted to pass a constitutional amendment that would in fact make flag burning illegal. They came very close in Congress within one vote. The amendment failed in 2006. The states still would have to ratify it, but anyway, the amendment failed. Justice Scalia, by the way, was on the side of Johnson, which is kind of interesting in that particular case, 5-4 case. Finally, Virginia versus Black was a cross-burning case, an interesting case in which the state of Virginia passed a law that made it illegal to burn a cross on someone else's private property, on a public highway, or on any public property with the intent to intimidate. And furthermore, the law said that the very act of cross burning was on the surface considered, was prima facie considered an act of intimidation. So why say this is interesting? I say that this is interesting because the very act already presumes intent. So if you burned a cross on someone else's property or on public property, you were guilty of crime of intent to intimidate, which was a felony in Virginia, unless you can prove that your intent wasn't that. So the burden of proof was automatically on you. So the law said you burn a cross, and that's already by definition kind of a felony, because it by definition assumes that the intent is to intimidate. The Supreme Court said that this law is overly broad because it cannot interfere with speech to such a great extent. It cannot simply assume on the surface, prima facie, that the very act of cross burning necessarily means intimidation. So Black wins and Virginia loses. Thank you.